Hello everyone, welcome to online session of monologue classes. My name is Dinesh Kumar. I'm former assistant professor of law at Campus Law Center and presently I'm working as an academic head of monologue classes. In today's session, I will discuss one legal passage for the purpose of CLAT examination and some of the questions for the purpose of AILET examinations and other law entrance examinations. Before moving forward, there is an important announcement for all of you. We have just started two courses, that is 1 year course and 2 year course for the upcoming batch of CLAT 2022 and 2023. You can get yourself enrolled with us for getting the best result. For more information, you can dial the number given on the screen, and you can also visit our website, that is www.lawandtrendsindia.com. We are also providing 15 days free trial for the students. And in these 15 days free trial, you will get live classes with one-to-one interaction. Second, recorded conceptual lectures on various topics. Third, topic test. Fourth, sectional test. And fifth, we will also provide you your feedback or of your performance on the basis of the analysis by our expert team members. To avail this facility, first of all, you should find the link in the description below. Then locate sign up for 15 days free trial. Then fill the form and you are set, or you would be eligible to get this benefit. So dear students, today I will discuss with you one legal passage that is based upon the landmark judgment of Hon'ble Supreme Court in the case of EP Yorappa versus State of Tamil Nadu. Because as you are aware, in CLAT examination, it has changed its pattern and now it is fully or completely passage-based exam. As far as the LA part is concerned, you are given 7 to 8 passages in LA part or around 40 questions. So here, it is very important to all of you to understand how to read the passage quickly, how to solve the passage-based questions, because the nature of questions which is asked in your CLAT examination is not easy. And the examiner does not ask the factual information given in the passage. Rather, examiner asks the question by asking any implied situation which is based upon the passage. So it becomes very difficult for any student or for every student to solve these kind of questions in the exam in a time-bound manner. So before moving to the questions or the passage, I would like to give you certain suggestions. Because in exam, you will not get the more time. You have to read a passage between 5 to 6 or 5 to 7 minutes. Because if you will give more time to one passage, then obviously you will have to compromise and then you will leave the questions. And leaving the questions will affect your rank, and your rank will affect your admission in the CLAT. So dear students, today I will discuss with you one legal passage that is based upon the landmark judgment of Hon'ble Supreme Court in the case of EP Yorappa versus State of Tamil Nadu. Because as you are aware, in CLAT examination, it has changed its pattern and now it is fully or completely passage-based exam. As far as the LA part is concerned, you are given 7 to 8 passages in LA part or around 40 questions. Now, our today's passage is based upon Article 14 and Article 16 of Constitution of India. As all of you are aware that Article 14 and Article 16 are the part of the right to equality, that is a fundamental right under Part 3 of Constitution of India. So I'm reading it and explaining it for your help. Article 14 provides for equality before law and equal protection of laws within the territory of India. This means, so Article 14 gives the equality before law and equal protection of law within the territory of India. The protection of Article 14 is available to every person and it is not restricted to the protections to any citizen of India. Now, Article 16 Clause 3 provides that nothing in this article shall prevent the Parliament from making any law prescribing in the regard to a class or classes of employment or appointment to an office under the government or for any local or other authority within the state or union territory, any requirement as to the residence within the state. Means Article 16 Clause 3 provides that residence may be a ground of discrimination in some of the cases, and the justification of ground of residence as a discrimination would be upon the concerned state or on the Parliament, because Article 16 Clause 1 prohibit the ground of a residence as discriminatory, so it is not allowed. But Article 16 Clause 3 allow it with certain exceptions and certain reasonable classifications. Now, there shall be equality of opportunity to all the citizens. So here we understand that Article 16 gives the right to equality of opportunity in the job provided by the government of India or government of any state. So in all the public employment, or means in all the government jobs, every citizen will have the equal right, means that citizen can avail that job on the basis of certain qualifications as prescribed by the government. It is a distinct and independent fundamental right because of its great principle ensuring equality of opportunity in the public employment is vital to the building of a new class of egalitarian society envisaged in the Constitution. So basically, it is talking about the importance of Article 16, and it is providing that Article 16 ensure the equality of opportunity in the public employment, and it also help in creating a new class of egalitarian society. So egalitarian society means the society in which all are having equal opportunity and all the application of laws are equal to everyone. So the protection of laws is available to everyone and nobody is denied from the protection of law. Now we read further. Article 16 only in instance of application of concept of equality enshrined in Article 14. Article 14 is genus and Article 16 is species of it. This is again correct information. Basically, this right to equality is found from Article 14 to 18, and Article 14 is the main article. So that's why it has been referred as genus by the author of the passage. And since Article 15, 16, 17, 18 are the sub part of this article, and that's why it has been referred as the species of it or one branch of the main article. So Article 14 is the main article and Article 15, 16, 17 and 18 are the branches of it or sub part of this article. Now, it is founding faith to use the words. So here the author has taken the view of the words of Justice Bose. A way of life, it means subject to a narrow pandemic or lexicographic approach. So here author wants to express the idea that Article 14 and Article 16 of Constitution of India cannot be given a limited interpretation. Okay, because these articles are very important for ensuring the equality of law and ensuring the equal protection of laws. Now, this blue information is the crux of the passage. That's why I have highlighted it. And I told you in my suggestions that you should not focus on each and every word of the passage. Rather, you need to get the crux or the main information of the passage. examiner asks the question based upon that information only. Equality is a dynamic concept with many aspects and dimensions, and it cannot be cribbed, cabined, and confined within traditional or doctrinal limit. It means that the concept of equality is dynamic and it must be interpreted in a dynamic manner as our society progresses. So we cannot give a traditional approach or a confined approach or a limited interpretations to these articles. From a positivistic point of view, equality is antithetic to arbitrariness. So equality arbitrariness के against होती है. In fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a public, while others to whims and caprice of an absolute monarch. So, author wants to say that arbitrariness and equality are sworn enemies. Means if there is equality, there cannot be arbitrariness. Or if there is arbitrariness, there cannot be equality. Where an act is arbitrary, it is implicit in it that it is unequal both according to the political logic and constitutional law. So basically, in this case, Honorable Supreme Court gave the concept of a new concept of equality, and on the basis of this particular concept, if a law or if any decision of the government is arbitrary in nature, then such law or such decision of the government will be presumed to be arbitrary in nature or will be presumed that it is against the Article 14 of the Constitution of India. So, Honorable Supreme Court can declare such law or declare such order as the unconstitutional on the basis of its being arbitrary in nature. Article 14 and 60 strike at arbitrariness in the state actions and ensure fairness and equality of treatment. So basically, Article 14 and 16 ensure the or strike the arbitrariness in the state actions. Means state cannot take any action on the basis of arbitrariness. Rather, the decision of a state or action of the state must be based upon some logical conclusion or some reasonable aspect. They require the state action must be based on valent, relevant, applicable alike to all similar situated, and it must not be guided by any external or irrelevant consideration. Means if a state wants to take any action, then action must be based upon the law, and action must be such that it is good for every human being or every person as per Article 14 of Constitution. So I have taken this passage and edited and revised this passage from the decision of Honorable Supreme Court of AP Europa versus the State of Tamil Nadu and others. This decision was delivered by Honorable Supreme Court on 23rd November 1973. Now, there are certain questions which are based upon this passage. You may read the question and you will get these type of questions in your exam. As per my experience, and I have seen in the recent trade of the CLAT examination, your questions are not based upon factual information, rather they are based upon implied situation that may be based upon the information or the legal knowledge of the passage. So if I read this first question, the petitioner was a member of Indian Administrative Services Tamil Nadu. In November, when the position of Chief Secretary fell vacant, the petitioner was suitable for that post. So means the petitioner in this case was earlier a civil servant in Tamil Nadu, and after when he was doing his duty, then the post of secretary fell vacant, and the petitioner was suitable to that post. He was selected to that post with the consent of the chief minister. But what happened? Government of the state gave permissions and a new post was created, and the post was that of deputy chairman in the state planning commission. Then this petitioner was appointed from the post of Chief Secretary to the post of Deputy Chairman in the State Planning Commission. And after some time, junior of the petitioner was appointed to the post of Chief Secretary. So the petitioner challenged the decision of government on the ground that it is in the violation of Article 16, read with Article 14 of Constitution. So I'm explaining this question again, that petitioner was the member of the civil service. He was at that time when he was doing his job, the seat or the post of Chief Secretary fell vacant, and he was appointed to that post with the permission of the Chief Minister. So basically, you know that the position of Chief Secretary is very important in comparison to the position of Deputy Chairman of the State Planning Commission. So once he was promoted to that post, and subsequently he was demoted from that post to the Deputy Chairman in the State Planning Commission. And one of his junior was appointed to the post of Chief Secretary. So he thought that he has been demoted, and which is not allowed under the civil services rule, and also not allowed under the Article 16 and Article 14 of Constitution of India, because all must be treated equally and in equal manner. So there are 4 options before you, and you have to read the options and give me the correct answer. The first option is government has violated Article 16, read with Article 14 of Constitution, and petitioner was demoted to the lower rank from higher rank, which is not allowed under Article 16, read with Article 14 of Constitution of India. This is option 1. And second, government has not violated. So according to option A, government has violated Article 16 and Article 14 because he was demoted, as per the contention of the petitioner in this question. Second, government has not violated Article 16 and 14 of the Constitution of India because it is the discretionary power of the government to take such decision. Second option is saying that it is the right of the government to take any decision, and this decision was taken by the government, so it's okay. Second, government has not violated Article 16, read with Article 14, because it is a case of reasonable classification. So means reasonable classifications means the government has discriminated between the two persons, and there is some reasonable classification or reasonable government with the reasonable opportunity or reasonable classification of such discrimination. Means government did not do this discrimination with the petitioner, rather there are certain reasonable grounds of doing so. And next option is government has not violated Article 16 read with Article 14 because it is a case of class legislation. So class legislation here means that first of all, government create a class and then government make the law for those that particular class. And reasonable classification means that government first of all make the law for whole of India, and then the government creates some discriminations in the application of that law on the basis of certain objective which the government wants to achieve. And fifth option is all the above. So now you may decide the option. So we have read these 5 options, and after these 5 options, if we see the information given in the passage, which option is most suitable? So in the given situation, we find that option A is most suitable as per the information given in the passage. Now we come to next question, and this question is, Government of Chhattisgarh introduced a Cobra force to counter the next light in the state. But in the notification is mentioned that only resident of Chhattisgarh can apply for such post. One of the residents from Delhi challenged this decision of the government on the ground that it is in the violation of Article 16 of Constitution of India. So I'm explaining it this again in Hindi. Means you know that, or I taught you in the passage, this Article 16 prohibit the discrimination on the ground of residence, that on the basis of residence, government cannot discriminate. But what happened in the given question? Government of Chhattisgarh wants to introduce a Cobra force. And the purpose of this Cobra force to counter the next light in the state. So दिस गवर्नमेंट ने नोटिफिकेशन में ऐसा मेंशन किया कि इस पोस्ट के लिए केवल छत्तीसगढ़ के रेजिडेंट ही एलिजिबल हैं और किसी स्टेट के रेजिडेंट इसके लिए एलिजिबल नहीं है. सो पेटिशनर दिल्ली का रहने वाला था, उसने इसको चैलेंज किया आर्टिकल 16 के आधार पर. अब आपको बताना है whether the challenge of the petitioner is sustainable according to the law or not. So there are 5 options again. First is, it is the violation of Article 16 of Constitution of India. पहले option के अनुसार the decision of the government was wrong. Second option, it is not the violation of Article 16 of Constitution of India because it is the policy decision of the government and court is not supposed to interfere in the policy decision of the government. तो सेकंड ऑप्शन कहता है कि दिस इज द पॉलिसी डिसीजन ऑफ द गवर्नमेंट एंड कोर्ट मस्ट नॉट इंटरफेयर इनटू द पॉलिसी डिसीजन ऑफ द गवर्नमेंट. सो द पेटिशनर इन दिस केस विल नॉट बी एंटाइटल्ड टू एनी बेनिफिट. थर्ड, it is the violation of Article 16 of Constitution of India because Article 16 provides that government cannot discriminate on the ground of religion or this residence. So गवर्नमेंट थर्ड ऑप्शन कहता है गवर्नमेंट रिलीजन या रेजिडेंस के आधार पर कोई डिस्क्रिमिनेशन नहीं कर सकती. सो दिस आंसर. फोर्थ, इट इज नॉट वायलेशंस ऑफ आर्टिकल 16 because such measures are allowed under Article 16 of the Constitution itself. And fifth is none of the above. So I have read 5 options before you, and now you have to find out the correct option on the basis of the information given in the passage. So dear students, you have to find the most relevant answer in the passage. There may be 2 answers which may be similar to the great extent, but you have to go with the most relevant and most appropriate one. Here the examiner may try to confuse you, so you have to be very specific for this purpose. Is it okay? Now, if we analyze all these 5 options, then option D is most relevant and most correct because such measures have been provided by the Constitution itself under Article 16 Clause 3 as I read in my passage. Basically, if the government of Chhattisgarh is creating a Cobra force, then to counter the main purpose of Cobra force is to counter the terror, next light activities or next light. Then the most suitable person for that post would be the citizens of Chhattisgarh because they know about the environment of Chhattisgarh, where are the forests, where the next light may be found. So this is a kind of reasonable classification which is allowed by the Article 16 Clause 3 itself. So this will not be a discrimination and the case of petitioner will fail in this particular question. So the correct option is D. Now we come to the third question, and the third question is, what is the view of author in this given passage? मतलब author का क्या view? So generally in this kind of question, you just have to give the what is the main idea of the author in the passage. So here we read the 5 options again. Option 1, arbitrariness is consistent with equality. Means arbitrariness is consistent with equality means there can be arbitrariness and there can be equality as well. Second, equality is a dynamic concept and it cannot be given limited interpretation. Equality एक dynamic concept है and it cannot be given a limited interpretation. मतलब इसको हम narrow meaning नहीं दे सकते. Third, where there is arbitrariness, there can be equality. जहां arbitrariness है वहां पर equality हो सकती है. Fourth, there is no relationship between arbitrariness and equality, and both are separate and independent concept. So fourth option में author कहते हैं कि arbitrariness और equality के बीच में कोई relationship नहीं है और दोनों अपने आप में independent concept होते हैं. And fifth option says all the above. So now I have read 5 options of this particular question. Now you have to suggest the most appropriate answer out of these 5 given options. So if we analyze or we recall the information of the passage, then answer B is the most appropriate one because equality is a dynamic concept and it cannot be given a limited interpretation was the view of the author in the passage. And this view was also provided by Hon'ble Supreme Court in this case. So the correct answer or the correct option would be B. Now we come to the question number 4. Rinku, an accused of committing murder and various other offences, was tried under the Uttar Pradesh Ordinance 1949. This ordinance was in force at the time of commission of the offence, but this ordinance was replaced by Uttar Pradesh Special Court Act of 1950. Means when the accused committed offence, he was subjected to the ordinance of Uttar Pradesh Court Ordinance 1949. But subsequently, this ordinance was replaced by the Uttar Pradesh Special Court Act 1950. And Section 3 of this Act gives power to the state government to establish a special court for the trial of certain offences, and the offence of accused was also tried by this court. Means there was no such provision in the ordinance when he committed offence, but subsequently an act was passed by the this state legislature, and Section 3 of this act gives the power to the government that government can decide that which cases will be tried by the fast track court and which cases will not be which cases will be tried by the normal court. The case of the government was first of all referred to the fast track court, and it was also decided by the fast track court by the result of conviction of the accused. Means this fast track court convicted accused. Now, accused filed a writ petition in the Hon'ble Supreme Court on the ground that this act has violated his fundamental right under Article 14 of Constitution of India, which provide equality before law or equal protection of law. So we try to understand the contention of the accused here. He contended that if I would have been tried by the normal court, then it would have been taken around 10 years, 15 years, 20 years in my conviction. But now I have been tried by the fast track court. So I was convicted earlier by the court. Second contention or the second point, we may understand that by virtue of Article 20, Clause 1 of Constitution of India, which provides for the doctrine of ex post facto laws, a person is liable only for the law or only for the offense which he has committed at the time of commission of the offense, and he is subject to only that law which was applicable at the commission of the offense. So when the accused committed offense in the given case or given question, at that point of time, Uttar Pradesh Court Ordinance was applicable and this act was not applicable. This act gives the arbitrary power to the state government to decide that which cases will be tried by the special court, hence arbitrary in nature. So the main contention of the accused was that the section 3 of this act, means Uttar Pradesh Special Court Act, give the arbitrary power to the state government to decide that which cases will be tried by the special court or by the fast track court and which cases will not be tried. So it was the contentions that this section gives the arbitrary power. So as we study as we read in this passage that arbitrary is against the equality, so he wanted that his conviction should be set aside. So there are again 5 options. Option 1, Rinko will succeed in this case because his contention is legally sustainable. पहला ऑप्शन कहता है कि रिंको सक्सीड करेगा और उसकी जो कंटेंशन थी वो कानून में मानी जा सकती है. सेकंड, दिस एक्ट means the Uttar Pradesh Special Court Act 1950 is against Article 14 of the Constitution of India and it violates Article 19 and 21 of Constitution of India. तो सेकंड ऑप्शन कहता है कि ये जो एक्ट है इसका सेक्शन 3A एक्ट आर्टिकल 14 के और आर्टिकल 19 और 21 के अगेंस्ट है. अब नाउ यू मस्ट नो दैट what article 19 provides for and what article 821 provides for. Third point was that this act is against article 14 because it gives arbitrary power to the state government to decide that which cases will be decided by the special court. So third point या third option कहता है कि this act is arbitrary because it gives arbitrary power to the government to transfer or to decide the nature of case. Next, this act is not against Article 14 because it is a policy decision of the government and it is a welcome step in the direction of speedy trial. So fourth option कहता है कि ये एक welcome step है and it will lead to the speedy trial in the country. And fifth option is none of the above. Now you should understand most of the students will go to option D. So most of the students will go to option D because they will think that this is a welcome step by the government in the direction of speedy trial. And this option will be wrong. And my dear students, examiner tries to play this kind of trick. Examiner gives you a option in the given options which appear you to be correct, but that is not correct. So here all of you have to be very, very careful to understand this trick of examiner. So in the given question, option C is correct because section 3 of this act gives arbitrary power to the government and this arbitrary power is against Article 14 read with 16 of the Constitution of India. Because there was no classification, there was no logic, and there were no rules on the basis of which government will decide that which case will be transferred or which cases will be transferred to the special court and which cases will not be transferred. So there is no criteria to decide that which cases will go and which cases will not go. Then such measure by the government or by the state legislature would be considered to be arbitrary in nature and hence it would be deemed to be against Article 14 read with Article 16 of the Constitution of India. Now we come to the question number 5. Which of the following correctly explain the meaning of the phrase equality is antithetic to equality? As I told you in the beginning of my lecture that examiner may ask a question based upon the legal maxims used in the passage or a legal phrase used in the passage. So same is here. So here in this question number 5, examiner is asking that what is the meaning of this phrase, equality is antithetic to arbitrariness. So first meaning is, first option is equality is against arbitrariness. Equality arbitrariness के against होती है. Second, equality is not against arbitrariness. Equality arbitrariness के against नहीं होती है. Third, arbitrariness is opposite to equality. Arbitrariness opposite के equality के opposite होता है. Both are independent from each other. दोनों एक दूसरे से अलग होते हैं. So, and fifth option is all the above are correct. Some of the students may commit the mistake when they are not able to find out the correct answer of a question, then they just pick the option 5, and that is the all the above are correct. So you must not do this. You should try to understand the 4 options, and these 5 options, all the above are correct, is given to make you confused in the exam. So if you are not able to find out the particular or specific answer, then you should read the options again. Okay. If we talk about this particular question, equality is against arbitrariness. Arbitrariness is opposite to equality. So the option C would be the correct answer, because arbitrariness is opposite to equality, as we discussed in the paragraph as well. Now I will discuss with you 4 questions. These questions are based upon AILET pattern. In AILET, most of the questions are on this basis, or they are based upon the principal fact-based situations. Some of the questions in AILET or in other examinations may be simple in nature. They may be based upon the simple MCQ type. But now, as you are aware that the pattern of the exams are being changed every year, and this pattern is being tough every year. So we also need to change our approach according to the changing pattern of the exam. Dear student, the most important thing to solve the AILET based questions or AILET pattern based questions is that, first of all, you must understand the legal principle. What used to happen earlier, examiner used to give only single legal principle. So it was easy for you to answer the question based upon single legal principle. But now examiner has changed its pattern, and he has made the exam more difficult by giving so many legal principles. I have seen in the CLAT exam, there are 6 to 7 principles. So these more principles are given to you to make you confused in the exam. But you have not to be confused, and you will not fall into the trick of examiner. As we are telling you, we will provide you the best guidance available in India. So if you will stick to our guidance, then you will not commit any mistake in every type of questions which is asked in the CLAT or AILET or any other law entrance examination. You need not to worry about the number of legal principles given by the examiner. But what you need to do, you need to read, you need to understand the legal principle in a very particular manner. And you need to understand the legal principle technically as well, because there will be little difference, and this little difference will be injurious to you. So first point is this: you should read the principles and try to find out the most appropriate one. Second, as a general rule, 80%, the rule is this: the legal principles may be based upon current legal position of the country. But Examiner has now started to play a game here as well. Now examiner gives you a wrong legal principle. So whatever you have been taught in your coaching institutes, that is the examiner asks the just opposite question from that. For example, I taught you or in my legal passage that Article 14 gives you equality before law and equal protection of laws. So this is the principle and this is the present situation of our country. But examiner may give you the legal principle that Article 14 of the Constitution of India does not give the equality before law and equal protection of laws. So this is the opposite information. But you have to be very cautious here and you must answer on the basis of the legal principles. Whether this legal principle is correct or wrong, your answer must always be based upon legal principle of the given question. Is it okay? So now we come to this first question. Dishonest misappropriation of property. Whoever dishonestly misappropriate or convert to his own use any movable property shall be punished with imprisonment of either description for a term which may extend to 2 years with fine or with both. So means if a person criminally misappropriate the property of other, then such person is liable to get the punishment of that may extend up to 2 years or with fine or with both. Now, second principle, criminal breach of trust. Whoever being in any manner entrusted with the property or with any dominion over property dishonestly misappropriates or convert to his own use that property or dishonestly uses or disposes of that property in violations of any direction of law prescribing the mode in which such trust is to be discharged or any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any other person so to do commits criminal breach of trust. So basically, criminal breach of trust is providing that if a person has been entrusted with some property and he dishonestly misappropriate of that property, or if he takes any decision with respect to that property in a against the or opposite to the given direction with respect to that property, or if he does any act which is contrary to the legal contract between the parties, and this legal contract may be express or implied, then such person is said to commit the offense of criminal breach of trust. Third option is cheating. Third legal principle is cheating. Whoever by deceiving any person fraudulently, dishonestly induces the person so deceived to deliver any property to any person, means जो कोई व्यक्ति किसी व्यक्ति को फ्रॉड के तरीके से, बेईमानी के तरीके से इंड्यूस करता है कि वो व्यक्ति उसको अपनी प्रॉपर्टी दे दे, और टू कंसेंट दैट एनी पर्सन शैल रिटेन एनी प्रॉपर्टी, कि उससे हम चीटिंग के आधार पर, फ्रॉड के आधार पर ये कंसेंट लेते हैं कि दैट ए पर्टिकुलर पर्सन विल होल्ड दैट पर्टिकुलर प्रॉपर्टी, or intentionally induces that the person so deceived to do a property or deliver a property to anything which he would not do or omit if he were not so deceived. So if we are compelling a person or if we are deceiving a person to do a particular act and that person would not have done that act if he was not so deceived, it will also fall under the definition of cheating as per IPC. Then such person is said to cheat that person, or this kind of offense is known as the cheating. A dishonest concealment of fact is a deception within the meaning of this section. So if a person is concealing certain fact with a dishonest intention, this will come under the definition of deception of as per the definition of cheating provided by IPC under section 415 of Indian Penal. Now, examiner has given you three three legal principles. And this question which I am going to ask, it would be based upon only one legal principle. So, you should understand that these two principles have been given to make you confused in the examination. So you have to be very cautious here, and your answer must be based upon the correct legal principle, and you can understand this by reading the three principles in a proper manner and understanding the meaning of all the principles given in the question. Now, a question. Ashok, residing in Delhi, is agent of Sohan, residing at Kanpur. Means Ashok Delhi में रहता है, Sohan कानपुर में रहता है. There is an express or implied contract between Ashok and Sohan. अशोक और सोहन के बीच में एक एक्सप्रेस और इम्प्लाइड कॉन्ट्रैक्ट है. That all sums remitted by Sohan to Ashok shall be invested according to the direction of this Sohan. Means whatever amount this Sohan will give to Ashok, Ashok will invest this amount as per the direction of Sohan. So this was a contract between the two parties. According to Sohan direction, Sohan remits 1 lakh of rupees to Ashok. Sohan 1 lakh rupees Ashok को दे देता है. With the direction to invest the same in company B. तो सोहन अशोक को जब 1 लाख रुपए देता है तो उससे कहता है कि वो उसको कंपनी बी में इन्वेस्ट करेगा. But Ashok in good faith, believing that it will be more beneficial for Sohan's advantage to hold share in the company C. लेकिन अशोक अपने गुड फेथ में उसके पैसे यानी कि सोहन के पैसे कंपनी सी में इन्वेस्ट कर देता है, और ऐसा अशोक को लगता है कि अगर मैं सोहन का अमाउंट या सोहन के पैसे कंपनी सी में इन्वेस्ट करूंगा then it will be more beneficial for him, and he buys the share in company C. It causes loss to Sohan. इसने सोहन को लॉस कॉज किया. Means Ashok was thinking that it would be beneficial for Sohan, but actually it happened to be detrimental to Sohan, and it caused loss to Sohan. Decide what offense has been committed by Ashok in the given situations. So now you have to decide what offense has been committed by Ashok in the given situation. So there are 5 options before you, and option 1 is criminal breach of trust. Option 2 is criminal misappropriation of property. Option C is disobeying direction punishable under section 465 of Indian Penal Code. And option D is no offense, and option 5 is all the. There will be challenge before you, because I have seen 3 principles above. One was relating to criminal misappropriation, other was relating to misappropriation of the property, and other was related to breach of trust, and third was related to the cheating. But there is no option of cheating, so we should leave the principle of cheating. Second, criminal breach of trust. So now we should read the definition, or we must understand the definition of criminal breach of trust. So we have read in the definition of criminal breach of trust that if a person dishonestly disobey the direction of any person who has entrusted property to him, then such person will be liable for criminal breach of trust. In our factual situation, he dishonestly, or means Ashok dishonestly did not dishonestly invest that amount in the company C. Rather, Ashok invested that amount in company C in good faith. So the principle of criminal breach of trust is also not applicable. As far as criminal misappropriation is concerned, it will not be applicable, because in criminal breach of trust, property is not entrusted to anyone. So property comes to the accused person by any other way, and it is not entrusted by the owner of the property to the accused person. So option B will also not work here. Now, disobeying direction punishable under 465. So this has been created to make you confusion, to create confusion in your mind by the examiner, because examiner know that you may not remember all the sections of IBC. So examiner just created option to make you confused in the exam. So this is not relevant as well. Now we come to 4. So the correct answer of this question is option 4, no offense. Means if Ashok would have invested that money in company C with dishonest intention, then Ashok would have committed the offense of criminal breach of trust, and answer A would have been correct. But in the given situation, since Ashok invested that money in good faith for giving more benefit to Mr. Sohan, so here there is no dishonest intention, there is no mens rea on the part of the Ashok, so Ashok will not be held liable for any offense. So you have to be very careful in these type of questions. So that's all for today. Please take care of yourself, observe COVID appropriate behavior, and follow the guidelines of the government. Please wear the mask. I will come again with the next legal questions of the month. Till then, goodbye and thank you very much. Please take care of yourself.